Punjab IPS officer's book on anti-defection law was launched. Anti-defection law not applicable in president's election. Centre cutting at root of democracy. Uttarakhand High Court. Supreme Court. AG's argument on MLS preposterous. Office of Prophet Bar. Is it relevant in the face of anti-defection law? Powers in anti-defection law need to be redefined. BJP moves speaker seeking Mukul Roy's disqualification. Supreme Court sets the rule, disqualified MLAs can't be barred from contesting future elections. Speaker disqualifies 4 JDU MLAs in Bihar Legislative Assembly. Andhra CM Jagan Mohan Reddy moots disqualification of the defectors.
Wondering what these articles are about. After looking at them, you can observe one thing in common, that is anti-defection law and its disqualification. In simple words, anti-defection law is voluntarily giving up the membership of the political party, and the use of this law is common in every legislature assembly of India. Moreover, instead of using it for the better, it has turned into a disguise. Let's go through various aspects of anti-defection law in this video.
Ayaram Gayaram, which means Ram has come, Ram has gone. This is an expression used commonly in Indian politics to refer to political horse trading, frequently turncoating and floor crossing. The term originated when in 1967, when Gayalal, a member of the Legislative Assembly from Pataudi Vidhan Sabha constituency of Haryana, he won the election as an independent candidate and joined the Indian National Congress Party and thereafter changed his political party thrice in a single day. Even after this incident, Gayalal, a frequent floor crosser, frequently came switching parties and contested elections under different parties, such as in 1972 he joined Akhil Bharatiya Arya Sabha, and he also joined the Bharatiya Lokdal under Chaudhary Charan Singh in 1974 and became the source of the coining of the term Ayaram Gayaram. The Anti-Defection Law of 1985 was passed to prevent defections. It was included in the Constitution under Rajeev Gandhi's rule as the 10th schedule of the Constitution of India. It applies to both Parliament and State Legislative and specifies the process for the Speaker of the House, who is the presiding officer of the legislation, to disqualify a member of legislation on the petition of any member of the House. The main intentions of the law were keep political corruption in check, bring stability in politics to strengthen democracy, ensure that members of the legislation more responsible and loyal to their political party.
Legislators may be disqualified on grounds of defection by the presiding officer of a legislature based on a petition by any other member of the House. A legislator is deemed to have defected if he either voluntarily gives up the membership of his party or disobeys the directives of the party leadership on a vote. This implies that a legislator defying, abstaining, or voting against the party whip on any issue can lose his membership of the House. The law applies to both Parliament and state assemblies. Legislators may change their party without the risk of disqualification in certain circumstances. The law allows a party to merge with or into another party, provided that at least 2/3 of its legislators are in favor of the merger. In such a scenario, neither the members who decide to merge nor the ones who stay with the original party will face disqualification.
After the Anti-Defection Act of 1985 came laying tough conditions like at least 2/3 member of a party have to be in favor of a merger in another party or formation of a separate group from the parent body. The 2008 Operation Lotus exposed the chinks in the armor of this seemingly tough law. The successful circumvention of the Anti-Defection Law opened a new door for the shortcut to power. Operation Kamal ensured how the BJP, with 110 seats and running short of just 3 for a simple majority in the House, managed majority after a number of Congress MLA resigned, bringing the majority mark in the House. They later contested on BJP ticket. It played out again in Karnataka in 2019 when nearly half a dozen MLA from both party from Congress and JD got expelled and were elected again from the rival party. In Madhya Pradesh, Kamal Nath government of Congress fell in March 2020 when Jyotiraditya Scindia quit Congress and joined the BJP, triggering the resignation of nearly 2 dozen MLA, which reduced Congress number and brought BJP to power. India has a peculiar brand of politics and most of us does not respect democratic value and institution. This is why Just having a law is meaningless as political party will find a way to skirt it. Another bastion of Congress has fallen with the Congress-led Puducherry government falling. Chief Minister B. Narayanaswamy resigned even before a trust vote as 4 of his MLA resigned, plunging his party into minority in the picturesque Union Territory of Puducherry. After the recent resignation of 5 of its MLA egged on by the BJP, it was a foregone conclusion that the government would fall when the state was on the brink of state elections. While the political uncertainty over the desert state is over for the time being with Rajasthan Chief Minister Ashok Gehlot winning a trust vote, the month-long high-voltage political drama starting with the revolt of 18 MLAs of Pilot camp once again brought the sharp focus the need to further strengthen the anti-defection law. After the trust vote was over, Gehlot alleged that BJP conspired to engineer defections. Ironically, for the Congress, history is said to repeat itself with the chickens coming home to roost. In the Legislative Assembly of Telangana, 13 lawmakers, 2/3 of the Congress flock in the assembly crossed over to TRS after being elected 4 months ago. In the Legislative Council, the Congress has only a lone member, T. Jeevan Reddy, after a mass defection of its stock. Similar is the course of turncoat politics in the neighbouring Andhra Pradesh. Although the Telugu Desam party lost 13 out of 15 MLAs to TRS in Telangana, its leader N. Chandrababu Naidu to patronize turncoat politics back home in the native state, taking 23 lawmakers from the YSRCP into his party and even induced 4 of them in his cabinet. In July 2019, 10 of 15 Congress MLA from Goa joined the BJP. In 2016, 43 of 44 Congress MLA, including Chief Minister Prema Kandu, has deserted the parent party and joined the People Party of Arunachal. Defection did not spare even Rajya Sabha, where a single member from party straight away defected to the other party. The cases of anti-defection law are numerous, but one thing that stood out in the whole drama was the reminder of how numerous governments have fallen down the years and how the anti-defection had failed to do what it was originally designed for.
Any question regarding disqualification arising out of defection is to be decided by the presiding officer of the House. After the Quixote Holland case 1992, the Supreme Court declared that the decision of the presiding officer is not final and can be questioned in any court. It is subject to judicial review on the grounds of malafide, perversity, etc., although it has been subjected to further judgments given by the Supreme Court of India.
The law initially stated that the decision of the presiding officer is not subject to judicial review. This condition was struck down by Supreme Court in 1992, thereby allowing appeals against the presiding officer's decision in the High Court and the Supreme Court. However, it held that there may not be any judicial interventions until the presiding officer gives his order. In 2015, the Hyderabad High Court refused to intervene after hearing a petition which alleged that there had been a delay by the Telangana Assembly Speaker in acting against a member under the anti-defection law. Judicial review, as per Rule 7, which bars the jurisdiction of the courts in any matter connected with disqualification of a member of a house, which states that it is outside the jurisdiction of all courts, including the Supreme Court under Article 136 and High Courts under Article 226 and 227 of the Constitution, to review the decisions made by the Speaker in this regard. This can have a terrible consequences in the light of difficulties enumerated above. The legislature, in a way, tried to restrict the power of the judiciary proved under the Constitution, which is not tenable. The rule barring the jurisdiction of the courts has been challenged multiple times before the courts and the court in Quixote Holland versus Zaichlu and others. 5 people held because of validity of the law in all respects to expect on the matter related to the judicial review, which was held as unconstitutional and it also upheld that sweeping discretion available to the Speaker in deciding cases of disqualification of MLAs and the presiding officer's decision of disqualification shall be open to judicial review. Any law affecting Articles 136, 226 and 227 of the Constitution is required to be ratified by the states under Article 368 subclause 2 of the Constitution. As the required number of state assemblies has not ratified the provision, the Supreme Court declared that the rule be unconstitutional. The court also held that the Speaker, while deciding the cases on anti-defection law, acts as a tribunal and no decisions are subject to the review of the power of High Courts and the Supreme Court. Mentioning rule of caution, the Supreme Court warned against the exercise of the power of judicial review before making any decision by the Speaker. However, the Supreme Court has upheld the provisions granting the presiding officer the power to take the decision on the ground that the speakers or chairman can hold a pivotal position in the scheme of parliamentary democracy and are guardians of the rights and privileges of the House. They are expected to take far-reaching decisions in the functioning of parliamentary democracy.
A legislator is deemed to have defected if he either voluntarily gives up the membership of his party or disobeys the directives of the party leadership on a vote. This implies that a legislator defying, abstaining, or voting against the party whip on any issue can lose his membership of the House. The law applies to both Parliament and state assemblies. Para 2, Clause 1, Subclause A of the Anti-Defection Law explains about the voluntarily giving up of the membership by the member. This was cleared in the case of Ravi S. Nayak versus Union of India in 1994. In this case, the Supreme Court gave a wider prospect to resignation by voluntarily giving up the membership. The court observed that a person may voluntarily give up his membership of a political party even if he has not tendered resignation from the membership of that party. Even in the absence of a formal resignation from membership, an inference can be drawn from the conduct of a member that he has voluntarily given up his membership of the political party to which he belongs. The act of giving up membership can be expressed or implied. This was observed in the case of G. Vishwanathan versus Honorable Speaker, Tamil Nadu Legislative Assembly in 1996. It was opined in this case that the act of voluntarily giving up the membership of the political party may be either expressed or implied. When a person who has been thrown out or expelled from the party which set him up as a candidate and got elected joins another new party, it will certainly amount to his voluntary resignation or giving up the membership of the political party which had set him up as a candidate for election as such a member. After hearing all this, we can clearly say that there are two grounds on which a member of a legislature can be disqualified. 1. If the member voluntarily gives up the membership of the party, he shall be disqualified. Voluntarily giving up the membership is not the same as resignation from a party. Even without resignation, a legislator can be disqualified if, by his conduct, the Speaker or Chairman of the concerned House draws a reasonable inference that the member has voluntarily given up the membership of his party. Second, if a legislator votes in the House against the direction of his party and his action is not condoned by his party, he can be disqualified. These are the two grounds on which a legislator can be disqualified from being a member of the House.
Due to anti-defection law, political dwindling caused by the frequent and unholy change of allegiance on the part of the legislature of our country have been contained to a very great extent. Yet, there is a need for a more rationalized version of anti-defection law which will help establish a truly representative democracy. The anti-defection law should incorporate laws under which separate committees should be constituted for investigating into cases of horse trading between the parties, and where members of these parties are found guilty, punitive sanctions should be imposed on them. Further, an embargo should be imposed on them for contesting elections so that these elements do not disrupt the active democracy of the country.